policing the police every single day, and doing what the Charlotte County Sun newspaper and local TV stations won't do every single day.
I'm Dave Champion. It's nice to be back with you again today. Several weeks ago, I made a video in which I discussed the fact that what I would like to see would be hundreds of thousands of Americans, business owners, filing lawsuits against these draconian measures by these tyrannical governors. And that hasn't developed, but what has developed is we are seeing an increase in the number of cases being filed against the governors for their tyrannical actions. It's interesting that the legal pundits are often referring back to United States Supreme Court cases to substantiate a state's authority to do this and such. However, there is a well-settled rule in the judicial system that if the fact circumstances are not similar, the case is not considered particularly persuasive. And that's exactly what we're seeing going on right now. I talked in another video about Jacobson v. Massachusetts, and that dealt with a vaccine, and it was smallpox, and 30% of the people who were infected with smallpox died, and the punishment was merely a fine. And so we had to take a look at all those facts to draw the distinction that that is not remotely what's going on now. Having somebody say, hey man, you need to take this vaccine or we're going to fine you, is not remotely like you have to stay home for a month, 2 months, 3 months. You have to close your business. You can't work. You go bankrupt. Completely. The fact situations are not remotely the same, yet people reference Jacobson when they're trying to support the state's authority to do these things. There's another case, I can't pronounce it, it's a bunch of French language. The state of Louisiana went to the United States Supreme Court in 1902, and again that's being cited because the Supreme Court declined to say that Louisiana had interfered with the U.S. Constitution by the state of Louisiana saying when immigrants were coming to the United States that they had to be quarantined. Now, the allegation was that they were quarantining immigrants from ports where there was no infectious disease, so why are you quarantining them? But nevertheless, they were quarantining immigrants. And the court only held that there was no violation of the federal Constitution in the state of Louisiana doing that. Again, the fact situation was thoroughly different. They were acting upon foreigners, non-American citizens, who had not yet stepped onto U.S. soil. They were saying, if you want to step onto U.S. soil, here's the requirement to do that. And the Supreme Court said that's not interfering in the federal Constitution. Again, could not be a more dramatically different set of fact circumstances, because what's being done now is being done to American citizens who have, in law, unalienable, fundamental rights. It is, we talk about it a lot about American exceptionalism, and in certain circles that's a big phrase, and I don't buy into that, with the exception of one thing. To me, what makes America exceptional is that our country was created, founded, and rooted in the concept that we have unalienable rights the government cannot tamper with. Have the courts ruled that those rights can be infringed upon to an extent in a situation such as an infectious disease? Yes, the courts have ruled that. State courts have ruled that. The federal courts have ruled that. But again, different set of fact circumstances. Those cases were not addressing a heretofore unknown mass suppression of the most fundamental rights of the public. Huge, huge distinction. Now, a lot of these cases that are being brought now are being brought on rather technical grounds, and the few that have actually been ruled upon haven't done very well. My personal view is that every single suit that's brought should be brought from the perspective of this is violative of unalienable fundamental rights. Now, a lot of these cases too, such as Jacobson and the Louisiana case from 1902 we were talking about, they existed before the Supreme Court had fashioned the strict scrutiny rule. Now, what the strict scrutiny rule means is that when the state takes an action that is in the public interest, a compelling state interest is the legal phrase, that it has to use the least restrictive means possible to achieve that. Is the least restrictive means possible mass suppression of the unalienable fundamental rights of virtually the entire state population, except those that it says, okay, you can go to work. Other than that, it's mass suppression of a slew of individual fundamental rights. So to me, that's the argument that should be made. We should be talking about individual fundamental rights. The attorneys should not be arguing these little niggling details. And with that, I want to read you comments by a couple of state Supreme Court justices. Now, the first one is out of the state of Pennsylvania. And unfortunately, what I'm about to read to you was the dissenting opinion. The court did not rule in a direction that I would have liked them to have ruled. And this is from Chief Justice Thomas Saylor. And he says, while the state undoubtedly has a compelling interest in trying to limit the spread of COVID-19, quote, greater account must be given to the specific nature of the exercise. Arbitrariness cannot be tolerated, particularly when the livelihoods of citizens are being impaired to the degree presently asserted. Clearly, Justice Saylor is tactfully saying the same thing that I'm saying, that the real issue here is the unalienable fundamental rights of the people being suppressed in a mass or wholesale fashion. By the way, that was not the grounds of the suit, and that is not the basis upon which the Pennsylvania Supreme Court declined to decide that case in a direction I would have preferred. In other words, the mass suppression of unalienable fundamental rights was not the basis of that suit, as I believe all of them should be. These remarks by James Blacklock, who is an Associate Justice of the Texas Supreme Court, probably are the remarks I've heard from judicial officers that I find kind of does it for me. I really like what he has to say, and I wanted to share it with you. And he says, all government power in this country, no matter how well-intentioned, derives only from the state and federal constitutions. Government power cannot be exercised in conflict with these constitutions, even in a pandemic. In the weeks since American government began taking emergency measures in response to the coronavirus, the sovereign people of the country have graciously and peacefully endured a suspension of their civil liberties without precedent in our nation's history. In some parts of the country, churches have been closed by government decree, although Texas is a welcome exception. Nearly everywhere, the First Amendment, quote, right of the people to peaceably assemble, has been suspended altogether. In many places, people are forbidden to leave their homes without a government-approved reason. Tens of millions can no longer earn a living because the government has declared their employers or their businesses, quote, non-essential. Those who object to these restrictions should remember they were imposed by duly elected officials vested by statute with broad emergency powers who must make difficult decisions under difficult circumstances. At the same time, all of us, the judiciary, the other branches of government, and our fellow citizens must insist that every action our governments take complies with the Constitution, especially now. If we tolerate unconstitutional government orders during an emergency, whether out of expediency or fear, we abandon the Constitution at the moment we need it most. Any government that has made the grave decision to suspend the liberties of a free people during a health emergency should welcome the opportunity to demonstrate, both to its citizens and to the courts, that its chosen measures are absolutely necessary to combat a threat of overwhelming severity. The government should also be expected to demonstrate that less restrictive measures cannot adequately address the threat. Whether it is the strict scrutiny or some other rigorous form of review, the courts must identify and apply a legal standard by which to judge the constitutional validity of the government's antivirus actions. When the present crisis began, perhaps not enough was known about the virus to second-guess the worst-case projections motivating the lockdowns. As more becomes known about the threat and about less restrictive, more targeted ways to respond to it, continued burdens on constitutional liberties may not survive judicial scrutiny. Let me share with you my view of Justice Blacklock's and Justice Saylor's remarks. To me, what they are telegraphing, because judges normally, Saylor was speaking as part of the dissent, so he's writing on behalf of his block of the court. I think there was 3 justices that held his point of view. However, Blacklock is not. He's merely speaking without a case in front of him. And there was a case, by the way, that came to the Texas Supreme Court, and the Texas Supreme Court rejected the case because the plaintiff had attempted to invoke original jurisdiction with the Texas Supreme Court, and the Texas Supreme Court said, no, that's not the way it works. You have to go to an entry-level court first on this issue. So it wasn't rejecting the basis of the suit per se, it was rejecting approaching the Texas Supreme Court in its original jurisdiction. Okay, so, but Blacklock's comments are not in the framework of that particular matter. Blacklock's comments are, in my opinion, and I've seen judges do this time and time and time again over about the last 3 decades, I've been looking at what justices say when they speak their mind rather than speaking in a court decision. And normally what they're saying is, hey man, you guys are not bringing this matter before the court in the way it needs to be brought. So let me make a public statement. They could be giving a speech before some sort of lawyer group or at a university ceremony or something. But they say, is essentially their message is, hey, pay attention, because as a justice that sits on that court, I'm telling you, these are the points we're looking for. So quit farting around with these other points and do these things so that you can get the decision that you want. Normally with this, it's an act of conscience on the part of the justice. The justice is fed up with the little niggling technical arguments that lose time and time and time again. And the justice is saying, can we just cut to the chase, use the correct argument? We'll get to the obviously correct constitutional decision here. And clearly Blacklock is saying that. He's saying, look, and he's even giving the governor a way out. He's even saying, okay, so maybe at the start, if the case had come before us at that moment, maybe we could have substantiated, or we could have validated that this was a correct course of action within the state and federal constitutions. He's saying, but he's clearly indicating that no, now it's not. It's the threat is not overwhelming. The measures are by far not the least restrictive, and on and on. You can go back and review the video into exactly what he said. But the point being that I believe Saylor and Blacklock are basically waving their arms at the attorneys in their states and saying, are you listening? Because I'm telling you how to win this matter. So I've long held, since I first brought up the issue that Americans by the hundreds of thousands need to be filing lawsuits throughout all of the 50 states on this. This has been the basis. What we've just talked about, what Blacklock was commenting on, is the basis I felt every single one of those suits should have been brought from the beginning. So the point of this video, thank you for hanging in with me all this time. The point of this video is the suits are happening, and it's only a matter of time until a plaintiff makes the correct argument, as we've been talking about, and it jumps, well, if they make the correct argument, it may well persevere at the entry court level, what is normally a district court level. And of course, if the district court disagrees with that correct argument, the odds are improved that an appeals court will approve that correct argument. And then, of course, we go to the Supreme Court, and if it's a place like Texas and the majority of judges feel like Blacklock does, then we'd be looking at some excellent case law. So if you're a business owner or anyone else considering filing suit of this nature over this matter, I hope you'll listen to Blacklock and listen to me, and this will be the basis of the suit you file. Thanks for being here. Take care. Bye-bye.
Hey Charlotte County, this is Charlotte County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.